Welcome to Rising Above Shadows of Abuse, RASA. Your host, Grace Offer. The Guardian, Australian News by Benita Kolovos, dated Thursday, 30th of January 2025. Rape is effectively decriminalized. How did sexual assault become so easy to get away with? Sitting in a book-lined corner office at Victoria's Law Reform Commission, Jennifer Coe is charting the considerable progress she says she's witnessed over her decade-long career working in the criminal justice system. When she first started out as a lawyer, she says the notion of consent was not discussed, and only victims of stranger rapes were taken seriously, but only if they hadn't been out late or dressed provocatively. In court, there were no restrictions on discussing a victim's sexual history, while defendants were allowed to make unsworn statements from the dock, essentially whatever they liked, without being under oath or cross-examined. This was 1992, not 1892, she says. People think this crusty old system hadn't been able to move and change. It's not correct. It really has developed and changed considerably. And yet, we know without doubt that the vast majority of girls and women who are sexually assaulted will not report to the police and do not want to go through a criminal justice system. The numbers tell the story. Australia's criminal justice system is failing victims, survivors of sexual assault. While 1 in 5 women over the age of 15 has been sexually assaulted in their lifetime, almost 90% will not report to police. Of the women who do make a report, only a quarter will see their perpetrator charged, and even fewer will see their perpetrator plead guilty or be convicted. From decade to decade, the numbers don't shift. According to Victoria Sentencing Advisory Council, there were 23,000 reports of rape to police between 2010 and 2019, but only 1,000 sentencing for rape offences. More recent data from New South Wales shows there were 9,138 sexual assaults reported to police in 2022, but only 1,016 convictions. After the #Me Too movement revealed the staggering prevalence of sexual violence, after the March for Justice women's marches that swept across Australia in 2021, the reality is that justice for victims remains elusive within the criminal justice system. The past year, the federal government's Australian Law Reform Commission has been conducting a review into justice responses into sexual violence, and the Attorney General, Mark Dreyfus, will soon table his report, addressing both outcomes of cases and the treatment of victim survivors. Michael Bradley, managing partner of law firm McQuill Lawyers, has represented hundreds of sexual violence survivors and chairs the Rape and Sexual Assault Research and Advocacy Initiative. He says, under Australia's criminal justice system, rape is effectively decriminalized. If you look at the probability someone's going to report to police, the probability police will prosecute, the probability someone is going to be convicted and punished for that rape, it's somewhere south of 1%. That is negligible, he says. The chances of actually facing consequences for committing rape are almost non-existent, and that is by design. And if we are all comfortable with that, then cool. Let's stick with what we've got, but I'm not. 2-year landmark inquiry by the VLRC into the criminal justice system's response to sexual offences, released in 2021, found most women will not come forward with their experience of sexual assault because they do not want to go through a criminal trial or because they fear they will not be believed. Research suggests that no more than 5% of all reported allegations are false. For those who end up going through the process, the inquiry found most sought validation rather than retribution. They wanted to have their story believed and heard. Instead, many come out more traumatized than they were when they went into it. As Dreyfus said in a statement, all too often, seeking justice adds to the trauma experienced by victims and survivors. In many cases, this is because the very principles that uphold the criminal justice system inhibit the delivery of justice to sexual assault victims. As a result, many academics and advocates, including Bradley, are calling for a complete overhaul of the system. The structure and ideology of our criminal justice system comes from another time, back to William the Conqueror, the first Norman king of England. In previous centuries, offenders were made to compensate victims to avoid blood feuds, and private prosecutions were commonplace, says Michael O'Connell, South Australia's inaugural Commissioner for Victims' Rights. But under William I, crime came to be considered a disruption to the king's peace. Rather than injuring the victim, crime produced a debt to the state, he says. The concept continued to evolve until the 19th century, when O'Connell says the bureaucratization of the criminal justice system was complete by the creation of a police force and public prosecutions. The right to silence doesn't work because it dips the scales entirely in the defendant's favor. Since then, the justice system has largely remained unchanged. This is the criminal justice system that Australia inherited on colonization. It remains a criminal justice system, not a victim justice system, O'Connell says. The former police officer says Australia's adversarial system lives up to its name, as it largely plays out like a dispute between two sides, the Crown or prosecutor, and the defense. Victims are rendered witnesses to a crime against the state and are almost entirely excluded from the criminal justice process, except when they are needed to testify. Dr. Kirsten Brown, senior lecturer in law at University of Southern Queensland, says the prosecutor does not represent the victim. Rather, they represent the Crown, the reigning king or queen, and serve the court and the public interest. This can create a conflict between the victim and the prosecutor because their interests and legal obligations do not always align, she says. For example, prosecutors are required to hand over all relevant materials to the defense, even if it is not in the victim's best interest or is favorable to the defendant. This can only come as a shock to victims who go into the criminal justice process with this common misconception, probably based on television shows, that the prosecutor is their lawyer, Brown says. Prosecutors are not the victim's legal representative, and while they will try to also represent their interests, they are not their representative in the way a defense lawyer is to a defendant. The cornerstone of the criminal justice system is that a jury must be convinced beyond a reasonable doubt that a crime had occurred. But in sexual assault cases, this can be a near impossible standard to reach. The prosecution holds the burden of proof, meaning it is their job to prove a sexual assault occurred. In most jurisdictions, this requires proving two key points: that the victim did not consent and that the perpetrator also did not reasonably believe they were consent. This can be difficult given sexual assault is usually committed by offenders known to the victims, and in the absence of witnesses or physical evidence, it usually means a complainant will need to give evidence and be cross-examined. They may also be required to hand over their phone, social media accounts, and text messages to be examined by both prosecutors and the defense. The defense can also request the victim's counseling notes and other confidential records. The accused has a right to a fair trial, a right to silence, and a presumption of innocence. They are not required to take the stand, and in majority of cases, they don't. Bradley says the measures are in place to protect a defendant from wrongful conviction, based on the concept called Blackstone's ratio, named after the English jurist William Blackstone, who in the 1760s wrote, "It is better that 10 guilty persons escape than that one innocent suffer." This argument can be traced further back to the 15th century when Sir John Fortescue, Chief Justice at the time of Henry IV, maintained that it was better that the guilty escape than the innocent be punished. But he says that in cases of sexual assault, the right to silence doesn't work because it dips the scales entirely in the defendant's favor. What it means is that when you get to trial, the only evidence the court hears is that of the victim, and so of course she goes on trial, he says. That compounded by the fact that the prosecution have to prove not just the act, but the absence of consent. And the only way they can prove that is through her. For the defense, the quickest way to raise doubt is to raise doubts about consent. Victorian defense lawyer, who asked for anonymity so they could speak freely, agreed. You kind of have to put the victim on trial. You've got to make the jury doubt them. Creating doubts in cases of sexual assault is not especially difficult because society's attitudes and understanding of the crime have changed very little over time. Stereotypes about how victims of sexual violence are supposed to behave, as well as rape myths, continue to feature in courtrooms around Australia, shifting the blame from the perpetrator to the victim. As part of the 2021 review, the VLRC commissioned Professor Julia Coulter from the University of Wollongong and Professor Luke McNamara from the University of New South Wales to analyze the transcripts of 25 rape trials in the County Court of Victoria from 2013 to 2020. Despite the introduction in 2017 of jury direction reforms in Victoria, which gave judges the power to instruct jurors that victims may not be able to recall all the details of an offense and describe it consistently every time. Coulter and McNamara found that in most trials, there was deliberate use of cross-examination questions to confuse or shake the complainant's account. Misconceptions also featured, including suggestions that the complainant was lying because they delayed in reporting the sexual assault. The majority of victims who experienced rape and sexual offenses delayed disclosing. All trials included evidence of the complainant or the accused being intoxicated at the time of the alleged rape. Lines of questioning also inferred consent to later sexual activity based on the complainant's clothing or flirtatious behavior. Another analysis of trial transcripts by Coulter and McNamara of NSW cases, the largest analysis of sexual offense trial transcripts in the state in almost 3 decades, found the majority of complainants were accused of lying and fabricating the event for an ulterior motive. The study incorporating 75 cases was conducted between 2014 and 2020 before NSW introduced new jury directions on consent and trauma. More than half were cross-examined for having failed to verbally communicate non-consent or failing to physically resist, while more than 3/4 were cross-examined for having an incomplete or inconsistent recalls of events. Research shows that victims are more likely to freeze and cooperate rather than fight off the offender. Trauma impacts a person's recall. Despite the 2017 reforms in Victoria, the 2021 VLRC review recommended introducing more jurors' directions and that they may be given at the earliest opportunity and repeated at any time during the trial. The recommendation was acted upon by the government in 2022 with a series of additional directions legislated, including that the person can be not consenting to a sexual act even if they are not threatened with physical violence or they do not protest or resist. The person can also not be consenting if they had slept with the person in the past, went to their home, or acted in a way that is perceived to be flirtatious or sexual. NSW's Law Reform Commission also made almost the same recommendations. In 2020, a new jury directions and consent laws came into effect in 2022. However, Holtz notes it will be difficult to assess the impact of the directions because it is prohibited in Australia to speak to jurors after they make their decision. Experts such as Mary, an associate professor of criminology at Deakin University and co-convener of the Deakin Network Against Gendered Violence, argued that the use of rape myths and the interrogation of complainants lead to significant re-traumatization of victims, which have long-lasting impacts. This is a problem when we consider that the integrity of the criminal justice system also rests on victims' confidence that the reporting of crime will not cause further harm or worsen existing harm, she says. This says the safety of the community is also at risk if victims are unwilling to go through the legal process. In light of these structural issues, experts have suggested reforms. The Reform Commission in NSW and Victoria have called for the use of independent experts to address topics such as how many memory works and why victims may display counterintuitive behaviors after a sexual assault, such as maintaining a relationship with the accused. Some submissions to the ALRC are calling for a more radical rethink, such as the Queensland Sexual Assault Network, which has suggested the introduction of a civil approach to sexual assault cases, where an accused will be held to the on the balance of probability standard of proof and required to take the stand. In last year's defamation action brought by Bruce Legerman over rape allegations broadcast by Network 10, it was found by Justice Michael Lee that on the balance of probabilities, Legerman raped Brittany Higgins. Legerman denies the allegation and is appealing that decision. He also suggests that bad character evidence relating to a defendant, such as the fact that they are a heavy drinker or use illicit drugs, will be admitted to trial in some circumstances, as well as inconsistent statements they have made. However, such changes have been met with skepticism by the Law Council of Australia, the body that represents all state and territory bar associations and law societies, which warns against undermining key safeguards of the criminal justice system: the presumption of innocence, the right to silence, the right to a trial by jury, the burden of proof resting on the prosecution, and the criminal standard of proof beyond reasonable doubt, all essential to the integrity of the criminal justice system. Submission to the ALRC inquiry read. This view was shared by criminal defense lawyers who spoke to Guardian Australia. We are talking about an outcome that could lead to someone being put in jail. That is no small thing, one says. The burden has to be on the state. The state has all the power, the money, the resources. They have to be able to prove it without any help from the defense. To shift the dial on that will be so completely alter the system. Another lawyer says the introduction of the affirmative consent laws in NSW, Victoria, and the Act in the past few years, which emphasize that consent to sexual activities should be actively communicated and cannot be assumed based on silence, had helped to even the scales. That is a major yet relatively new change. I don't think we are yet to see it fully play out, they say. Bradley says despite reforms, such as the broadly welcome introduction of affirmative consent laws, the adversarial criminal justice system remains ill-adapted to handle the nuance involved in sexual assault cases. The criminal justice system applies a strict binary to some very complex situations. It says either you're guilty and you are the worst person in the world and you need to be jailed, or you're not guilty and she's a liar and you've done nothing wrong. Forget this ever happened, Bradley says. It completely forecloses any possibility of the guy who's been accused of committing a rape admitting he's done anything wrong, because the consequences of admitting it are catastrophic. It has led him to see restorative justice as a possible approach for some sexual assault cases, because it would allow perpetrators to genuinely participate in a process that will provide the victim with some closure. Restorative justice, which has widespread support from police, prosecutors, courts, victim advocates, criminal barristers, and the VLRC, and is already in place in the Australian Capital Territory, brings together victims of crime and perpetrators in a facilitated environment guided by trained professionals and the support of counselors. Victims can explain the impact of the perpetrator's offending, while the perpetrator is supported to take responsibility, apologize, and make amends, in most cases without legal ramifications. Brown and Iliadis, however, said the only way victims will be given equity and a genuine role in the system is via the introduction of their own legal representation. Iliadis says the concept takes inspiration from the inquisitorial legal system in countries such as Germany, where victims of serious violent crimes are afforded the status of secondary prosecutor. They can engage lawyers to represent them, make submissions, cross-examine the accused, and make a closing argument. In Denmark and Sweden, victims of sexual offenses can engage a lawyer from as early as when they decide to report to police. But there is resistance to the idea of victims' lawyers within legal circles and at the VLRC. Code says while victims should be provided their own legal representation at particular points in the process, such as confidential communication applications, it will create problems in the trial process rather than solutions. The inquiry instead recommended they be provided with a victim's advocate to support them through the process. The inquiry also recommended lawyers receive special accreditation and training to appear in the sexual offense cases, which will be accompanied by higher fees, in an effort to attract the best people to the work. But Brown says such tinkering around the edges of the criminal justice system is not enough. We've been talking about this issue, how we can improve the situation for victims of sexual offenses for 50 years, she says. We can play around with the current structures of the adversarial system, and we have, but hasn't really changed much. It's time we try something else. Information and support for anyone affected by rape or sexual abuse issues is available from the following organizations. In Australia, support is available at 1-800-RESPECT, that is 1-800-737-732. In the UK, Rape Crisis offers support on 0808 500 2222. In the US, RAININ offers support on 800 656 4673. Other international helplines can be found at ibibli.org/RCIP/INTERNL.HCPC HTML. If you want more on this topic, kindly send an email to risingaboveshadows of abuse@gmail.com. Thank you.